now I would like to ask the next speaker, Mr. Tomasz Bojanowski, to show his opinion about the impact of hate speech on online content, censorship in the face of freedom of speech. The floor is yours, sir.
Maria, can you hear me?
Yes, I can hear you.
Okay, thank you. Good morning and welcome, ladies and gentlemen. My name is Tomasz Bojanowski, and I am a fourth-year student at the Faculty of Law and Administration of Cardinal Stefan Wyszynski University in Warsaw. Thank you very much to organizers for the opportunity to speak at the conference. The topic of my speech is impact of hate speech on censorship of content on the internet in relation to freedom of speech. The topic of freedom of speech and hate speech are related and interact with each other. Freedom of speech and hate speech have a great impact on content published online on social networking sites. In times of technological advancement and digitalization, parts of our lives are moving online. As a result, we are also using the internet to exercise parts of our rights. The internet and social media provide many opportunities, but at the same time can be a big danger because it can be a source of committing crimes and limitation of fundamental human rights and freedom. We live in time when freedom of speech and freedom of expression are guaranteed by both international and national law by specific regulation. The discussed human rights are deeply rooted in our culture. The legal state of affairs makes it impossible for anyone to question the human right of freedom of expression. It is a fundamental right resulting directly from the principle of a democratic state of law. Moreover, it is the core of democracy which allows for self-realization of civil society and individuals. However, recent times show that freedom of speech and freedom of expression are subject to more and more excessive restriction. Importantly for lawyers, these restrictions, which are harmful, do not have a hard legal basis. They are only a soft legal grounds. For example, regulation of social networking sites like Facebook or Twitter. Try to refer the phenomenon of the hate speech in order of control of the freedom of speech. The hate speech, on the other hand, is more undefined. In the legal orders of individual countries, there are provisions that criminalize behavior that meet the characteristic of hate speech crimes. However, there is no single legal definition of the hate speech in international law. Hate speech is regulated mainly by soft law acts, which do not have the force of universal law. This makes the definition of hate speech is still controversial. The conflict is going up by the politicization and objectification of the hate speech. Due to the international nature of this conference, it should be pointed out the definition of the hate speech has been developed by European Court of Human Rights, which in the judgment Erbakan versus Turkey indicated that tolerance and respect for equal dignity of human beings constitute that the basis of democratic and pluralistic society. Therefore, in certain democratic societies, it may be necessary to criminalize or even prevent any form of expression which dismisses, incites, promotes, or justifies hatred based on intolerance. Provide that any formalities, condition, restriction, and penalties imposed are proportionate to legitimate aim pursued. It is clear this passage that hate speech is speech that in cities promotes and justified hatred based on tolerance provides that the penalties are adequate. In connection with the presented interpretation of European Court of Human Rights on the hate speech, it should be pointed out that we use two approaches. The first one consisting in excluding from the convention protection certain behaviors in the case when they express hatred and negate of fundamental values of the convention, which involves preventing the derivation from the convention of a right to act that leads to the annihilation of rights and freedom set out the convention. The second is based on Article 10 in point second of the convention that is a limitation of protection when the speech constitutes the hate speech and is not likely to nullify fundamental value of the convention. In addition, the restriction must be considered necessary in the interest of national and public security, prevention of disorder crime, protection of health or moral and protection of the rights of freedom of other. The legal literature mostly supports the definition of the hate speech, and for the purposes of this article, this definition of hate speech should be adopted. However, some representatives of the doctrine argue that the subject definition of hate speech However, some representatives of the doctrine argue that subject of definition of hate speech may limit the normatively guaranteed human rights. Importantly, the definition based on the case law may be changed the course of further development of the line of jurisprudence. The standards of the European Court of Human Rights are replicated by the courts of national legislation. The problem arises in the case of social media, which have their own definition of the hate speech, which change very quickly. Defining the concept of the hate speech too broadly leads to censorships on social networks. The question that needs to be asked is whether this is a legal action. Censorship on the social networking sites has no legal basis. However, by creating an account on the portal, we accept its regulation. Acting against the regulation may result in removing the entry or temporary permanent suspension of account. If we believe that the particular action has been taken against the rule, we may file a civil lawsuit. For example, in the case of Facebook, this will be the court to be competent to lawsuit is Palo Alto in California, or his headquarters in Dublin for Europe. It means that Facebook stands above the Polish law and national law other countries. It means that the realization of the convention right to due process in this area are hampered. But that is not the subject of my paper. The Polish government has come out with a bill to protect freedom of speech on the internet. It's supposed to guarantee that there will be no censorship activities on the internet and the right to appeal in the event of controversial decision. But work has been suspended. Back to the point, Facebook relies on its users to detect abusive posts. These users can report offensive content on that they feel goes beyond free speech, but they must justify it. Such a request goes to one of 4 20-hour working operational units in the United States, India, or Ireland. There, within 72 hours, the request is proceeded by any of several hundred employees. The application of community standards determines whether a post will be removed. Each decision is a middle ground between protecting free speech and protecting reputation, but does not necessarily invoke a legal framework. Facebook recommends that hate speech be removed immediately. What is the hate speech, however, has to be redefined each time. Currently, it applies to content whose authors attack other users on the basis of race, ethnicity, nationality, religion, sexual orientation, gender, or gender identity, disability, or disease. Facebook new rules allow users to remove any content they find problematic. There is no objective criterion here based on the common law. Only the opinion on the administrator, who assumes that the role of community censor and decides which post can see the light of the day or not. Due to universal digitalization, social media has become a form for the unfinding view. However, the extensive action of administration of social networking sites cause that certain views are removed from the public space because they violate certain active standards which are an invention and have no support in the law. Of course, deciding to create an account on a given portal, we accept its regulation. This is a private business. We cannot infer in it. Nevertheless, we should consider an influence of social networks on censorships and outstanding favoritism of some view of expense of others. For example, there is no doubt that deleting the post of right-wing activists just because they represent a conservative views is not equal treatment and contradicts the idea of social network like Facebook. The internet should be characterized by pluralism and freedom of speech. It allows to express one's opinion and substantive criticism. Only insulting posts that fulfill the elements of the crime should be removed. The current practice calls that freedom of speech and the internet is successively limited in the name of political correctness and the selected ideologies. This is no different from censorship we had in Poland, Hungary, and other Eastern Bloc countries during the communist years. Therefore, we should think about whether the activities of social networking sites should not be regulated by national generally applicable law. The demand indicates is controversial, but in our reality, our pandemic reality, it is necessary to talk about this topic. If we want our society to remain pluralistic and in the freedom of speech, we must take legal steps in regard. This must be proceeded by proper research, analysis, and exchanges of view. Only in this way we'll be able to work out regulation. We will give a protection to the convention right to free of speech. If we do not this, we will lose something for our ancestors fought against the communist regime many years. Thank you very much for the opportunity to give my paper on conference, and see you again in the future. Thank you.
Thank you so much for your speech, Sarah.